Hello friends, session number 20 of the series on military law relates to and covers pre-trial procedure. Now, if any incident warranting disciplinary action has taken place, then the commanding officer of the accused or accused persons is required to ensure that pre-trial procedure as indicated in the army rules is scrupulously followed. We would see what all actions it involves in this session. And pre-trial procedure that would be studied now is to be seen in the context of suitable action. Primary reason for that is to maintain discipline within that body of troops, and also if there is a financial loss, then to regularize that. References for this session, you may see section 102 of the Army Act, and apart from that, rules 22, 23, and thereafter 177 to 186. As soon as an incident has taken place, in very many cases, a report has to be sent to higher authorities in the chain, in some cases right up to the army headquarters. That's a procedural mandation. If required, investigations are to be initiated by ordering a convening order. Then next stage would be a probe by way of hearing of charge under Army Rule 22. When that gets over, it calls for issue of suitable directions. Then maybe summary of evidence is to be recorded, and subsequently pre-trial procedure ends or extends to warning of accused for the trial. All actions at that stage or till that stage are included in the pre-trial procedure. Now, what's the reason for making a report to the higher formation headquarters? I said right up to army headquarters. It is to enable them to remain abreast with the state of discipline of that unit, and apart from state of discipline of that unit, also it has a bearing, it impinges combat readiness of that unit or that formation. And action at this stage, therefore, is mandatory for the unit to make reports and inform higher headquarters when so needed. Next stage is hearing of charge. Now, hearing of charge procedure is given in Army Rule 22. At this stage, charge is not very clear. Charge is only accusation that somebody has used a force to somebody else, say for example. Now, whether that use of force was normal causing of hurt, or it caused grievous hurt, or if it was attempt to murder, all that would be seen when the evidence is marshaled. Now, Army Rule 22 lays down the procedure how hearing of charge has to take place. It is the prerogative and the authority of the commanding officer, in commanding officer alone, to hear the charge, and the CO is required to dismiss a charge before him if he finds that the incident or the matter does not involve or does not amount to an offense under the Army Act. Now, the compliance of Army Rule 22 has a number of limbs or actions. Firstly, the accused is brought before the commanding officer, and the charge, which is an accusation at that stage, is read. Now, this process is carried out by a commanding officer in presence of two independent witnesses. And these two witnesses are merely, their role is to later on establish, prove, indicate that such an action was done. After the accusation is read, Maybe the commanding officer thinks it necessary to call one or two witnesses or see some documentary evidence. All this is written down. Accused thereafter is asked if he has anything to say. As far as the witnesses who had appeared to depose with regard to the charge, accused has an opportunity, is provided an opportunity to cross-examine them. At this stage, he may also produce his witnesses if his version is different than what has been brought out by the prosecution witnesses, and then the commanding officer issues his directions, which we would see in a later slide as to what are the four options available to him after hearing of charge. As indicated earlier, at this stage, it's not a formal charge. It is not to be written in section so-and-so of the Army Act that the evidence will bring out. It is just an accusation like for making away with equipment, stealing something, or deserting. So it is in that shape. It's a mere accusation because reason. Obviously, at this stage, evidence is not clear. It is yet to be marshaled, and the statements are yet to be recorded, which have not been done so far. Now, with regard to the charge that has been read out before him, a commanding officer shall dismiss a charge if the evidence does not show that an offense under the Act has been committed. Very simply, if nothing wrong has taken place, and by wrong it means an offense under the Act, then there is no need to proceed further. The charge shall be dismissed. Yet, the other option is that he has the discretion that he may do so. That means do so what? Do dismiss the charge. But unlike the first option, which is shall, here the word used is may. He may do it if he is satisfied that the charge ought not to be proceeded with. Now, to prevent misuse of the second option, it has been laid down that in what all situations a commanding officer cannot dismiss a charge. It's to be noted that Army Rule 22 is obligatory, and this is the first step in the disciplinary process for the maintenance of discipline, and that means prosecution. And this stage of Army Rule 22, which relates to compliance of hearing of charge, is mandatory. It's to be carried out even in situations of summary trial. Also, look at it this way, that Army Rule 22, hearing of charge, is the first stage where an accused can rebut and demolish the accusation made against him if he thinks it is baseless. So therefore, presence of an accused at the stage of Army Rule 22, and the next one, Rule 23, which pertains to recording of summary of evidence, is mandatory. This cannot be carried out in the absence of the accused, and it affords him the earliest opportunity to present his version with regard to the accusation that has been read out or that has been spoken before the commanding officer. The four options that were there with the commanding officer after the hearing of charge has been carried out are: number one, if he wants and within the authority available to him under Army Act Section 80, he can dispose of the matter then and there. The second option is that he can refer the case to his higher commander, which is to be done if the charge is ultimately to lead to district court martial, summary general court martial, or general court martial, because all those three types of court martials are outside the domain of the commanding officer to start. So therefore, it needs to be reported to higher formation headquarters. The other option is that the commanding officer wants evidence to be recorded. So this is called summary of evidence, and the commanding officer can order summary of evidence to be recorded. He can do it himself, or he can nominate one of the officers in his unit to record summary of evidence. And then the fourth option is he can hold summary court-martial thereafter. Now, summary of evidence, as the name suggests, it is the summary of evidence. Essential evidence is summarized, it is recorded. The procedure is contained in Army Rule 23. Presence of the accused is mandatory. The officer recording summary of evidence calls witnesses one by one. The accused is sitting there, and in the presence of the accused, the evidence is recorded as it pertains to the accusation, and then accused is asked, have you got any question to put to this witness? At the end of it, he is asked that would you like to say something? It is not necessary that you say, but whatever you say will be taken down in writing and may be produced in evidence. And he also has an option thereafter to call his witnesses or to produce, submit exhibits, material exhibits, if any. Summary of evidence can only be ordered by the commanding officer. He can record it himself or he can nominate one of his officers to do so. Obviously, a care is to be taken that the officer who has been ordered to do the recording should not himself be a witness in the matter. All relevant evidence which is relevant either for the prosecution or for the defense is to be recorded, a note is to be made of it, and accused to be cautioned, which I just told you, and that language of the caution is there in Army Rule 23, Clause 3, and then after the caution, if he wants to make a statement voluntarily, it is recorded. It would have become clear to you that at this stage, the rights of the accused are, number one, to be present at all investigations relating to pre-trial. Nothing is done behind his back. Secondly, he can cross-examine witnesses who are speaking against him or who are speaking for the prosecution. Thirdly, he has a right to call his witnesses, which will be called defense witnesses. He can produce any documents which he thinks are necessary for his case or exhibits. So this is his third right. And fourth is that he can make a statement himself voluntarily. Now these are four very valuable rights under the military law available to an accused at the stage of pre-trial investigation. The next stage is Army Rule 34, where the accused is warned. Warned means cautioned that, look, now the trial is going to take place. So he is informed before the trial about the charge. Now the charge is properly has been made. So he is told that on this charge, which relates to this section, infringement of the Army Act, statement of offense, particulars of the charge, that you have to stand at trial. And at that stage, an accused can inform his commanding officer if he wants any witnesses in his defense. So if he gives a list of names of witnesses, their particulars, then reasonable steps are taken to procure their attendance. So it is in the interest of the accused to intimate as to who all are likely to be his defense witnesses, so that if they are not available at that station or at that location, immediate efforts can be made to procure their attendance. The accused, when he is informed of the charges on which he is to be tried, in actual practice, a copy of the charge sheet is handed over to him. It is read in the case an accused doesn't understand English, and explained to him that, well, this is the statement of charge and these are the particulars of the charge. He is also given a list of the name, rank and corps of the officers who are to form the court. Now, say for example, a district court martial has to have minimum 3 members. So who are those 3 members, their name, to which regiment they belong, what is their rank, this is informed to the accused, and also if there are any waiting members, then their particulars are also informed. And the reason for this is quite obvious, because the accused has a right to challenge in case he feels that any of the members is disqualified or ineligible to serve in that court martial, so that he can do so if the names are given to him. And all this action is to be taken minimum 96 hours before his arraignment at the trial. That means 96 hours before the assembly of the court martial, all this action is to be taken. Well, if the situation is of active service, then the time is cut short and it is made 24 hours. At this stage, you may also note that in case the incident, which is the subject matter of the charge, saw involvement of more than one accused, it means that there was a gang or there was a group of persons who are alleged to have committed something, then they may be brought to a joint trial. Now, the procedure for joint trial is contained in Army Rule 35, which states that any number of accused persons may be charged jointly. They are all present together and they can be tried together for that offense which is averred to have been committed by one or more of them and abetted by somebody. Now that means that out of say 6 persons, maybe that 3 are being tried for commission of that, and the remaining 3 have the charge that they abetted other 3 in the commission of that offense. So this would be called a joint trial. Now, pre-trial procedure, before it actually starts, this warrants a detailed scrutiny by the commanding officer or the convening authority, which includes reading the evidence clearly. And then mind is applied and a suitable decision is made by the competent authority to decide as to which would be the best norm of trial or mode of trial for the disposal of that case, and that means what type of court martial is to be convened. Of course, this also depends and has a bearing on the rank of the accused. For example, an officer cannot be tried by a district court martial. So therefore, if the accused is an officer, it has to be a summary general court martial or a general court martial. And all this is to be carried out by the commanding officer himself, and his personal satisfaction is required. In the end, I would like to highlight that a non-compliance or if any infirmity is left at the stage of pre-trial, then that may result into a serious prejudice caused to the accused and may even run the risk of the trial finally being vitiated, and therefore there is a need, manifest need, to follow and scrupulously adhere to the provisions that are contained in the Army Act and rules for the pre-trial stage.